In this question, the principal explains to us about the concept of international commercial arbitration. That is, international commercial arbitration means an arbitration relating to the dispute which arise out of the legal relationship, whether it is contractual or not. Further, it is considered as commercial under the law in force in India. This is important criteria over here. Now, and where at least one of the parties is an individual who is the national of or habitual resident in any other country other than India, or body corporate incorporated in any other country other than India. So these are the essentials which have been mentioned in the principle, right? Now the facts. National Highways Authority of India entered into an agreement with SDM Infrastructure, whereby SDM Infrastructure, a company registered under the Indian Companies Act, was awarded the contract to upgrade and maintain Delhi-Chandigarh highway, right? Now, SDM Infrastructure subcontracted the maintenance part of the contract to the SB Group, a company registered under the Indian Companies Act, but whose central management and control was exercised in Brunei. Now, the agreement between the SDM and SB Group clearly mentioned that in case of a dispute, the same shall be referred to the arbitrator. A dispute having arisen as to the appointment of arbitrators, a question was referred to the court as to determine whether the arbitration agreement was an international commercial arbitration agreement or not. So, out of all the options, the correct option in this question is B. That is, the agreement was not an international arbitration commercial agreement, as both the parties were Indian nationals, right? Now let's come back to the principle and the facts. So if we read the principle, now we get to know that arbitration agreement is not an international commercial arbitration, as both the parties are companies incorporated in India, right? See, National Highways Authority of India, but obvious it is a company which is incorporated in India. In the same way, SDM Infrastructure is a company registered under the Indian Companies Act, right? Apart from this, SDM Infrastructure subcontracted the maintenance part to SB Group, a company registered under the Indian Companies Act, but whose central management and control was in Brunei. Now over here, it is of no consequence that the day-to-day management of the affairs of one of the company is being run in another country. If the company is incorporated in India, the company acquires Indian nationality, right? As is clear from the principle and as is clear from the facts. Further, therefore, we can say that this arbitration agreement between two Indian nationals cannot be termed as international commercial arbitration agreement, merely because the management and the control was exercised in Brunei, right? Now, principle 1, which is appended in the question, clearly states that at least one of the parties is an individual who is of a national or habitual resident in another country other than India, or a body incorporated in any other country other than India. So over here we get to know that both the companies have been incorporated under the Indian Companies Act, and therefore clearly it is not an Indian international commercial arbitration within the definition appended in the principle as applied to the given set of facts, right? The correct answer therefore is B.